video, we are going to compare and contrast the respective approaches of the English and Malaysian law of contract towards the doctrine of undue influence as a vitiating factor. My teammates and I will first discuss both English and Malaysian law towards the doctrine. By the use of case law and statutes, we will demonstrate both the Malaysian and English law's approaches towards undue influence, which includes actual and presumed undue influence, third-party involvement, and the remedies. After that, we will compare and contrast the similarities and differences between English and Malaysian law on undue influence. And lastly, we will give a conclusion. So what is undue influence? According to L.B. Curson in the Dictionary of Law, undue influence is defined as improper pressure on a person resulting in his being at a manifest disadvantage in relation to some transaction. Such a transaction may be set aside by the court. So how does undue influence act as a vitiating factor? In English law, there are three factors. The first one is the state of mind of innocent party, where impairment of claimant's decision-making process is caused by excessive reliance or dependence on the defendant and renders a party incapable of acting as a free agent. The second one is wrongful conduct of the defendant. It is unacceptable means of conduct by defendant, such as abuse of position of confidence, exploitation, and advantage taking. The third one is public policy, where it concerns the nature of a continuing relationship between the parties. It should not be disadvantage to the victim. In Malaysian law, in the case of Pusathurai against Kanapa Chettiar AIR 1920, there are two factors involved, which is domination of the will to obtain unfair advantage from the claimant, and the sale is unconscionable or unreasonable. Next, when does undue influence arise under Malaysian and English law? So in English law, undue influence arises if excessive authority or pressure brought to bear on a party to such extent that his free will is completely overcome by the other parties. Almost all cases of undue influence arise because a party who has authority or power over another uses this power wrongfully to exert his consent to agreement. In Malaysian law, it is under Section 16, subsection 1 of the Contracts Act 1950, where a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other.
Next, we'll be looking into greater details of actual undue influence and presumed undue influence. Under English law, according to the case of Royal Bank of Scotland versus Attridge, there are 5 elements of actual undue influence. Firstly, it is an equitable wrong committed by the dominant party against the other. Secondly, it must be unconscionable for the dominant party to enforce his legal rights against the other. Thirdly, there must be some express conduct overbearing the other party's will, and it does not depend on some pre-existing relationship between the two parties. Lastly, anyone who alleges actual undue influence must prove it. Actual undue influence, class 1, involve cases where one party had induced the other to enter into the transaction by actual pressure, which equity is regarded as improper but which does not amount to duress, as no element of violence to the person is involved. Under this category, there is no need for there to be a previous history of such influence. And also, there is no need to show the contract was disadvantageous to the victim. One of the cases under actual undue influence is the case of Williams versus Bailey. In this case, a father sought to resign a mortgage which he had executed in favor of a banker. He proved that he had executed the mortgage because he was frightened by the banker's warning or threat that he had in his power to prosecute his son for forgery. It was held that he was entitled to resign the mortgage on the ground of undue influence. Based on the case of Royal Bank of Scotland versus Attridge, there are 3 stages in successfully raising a presumed undue influence. The first stage is that there has to be proof of relationship of trust and confidence. Under this stage, there are 2 things that the claimant must prove. First, the claimant must prove that there was a special class of relationship. Second, claimant must prove on the facts that a relationship of trust and confidence existed between the parties. And lastly, there must be something about the transaction which calls for an explanation. If both of the two elements are present, there arises a rebuttable presumption of undue influence. Lastly, the court then should consider, based on all evidence, whether the presumption is rebutted. The more disadvantageous the transaction, the more cogent must be the explanation. As you can see from the diagram, the presumed undue influence is divided into two categories, which is Class 2A and Class 2B. Under Class 2A, the claimant only has to show that there was a special relationship between the claimant and the wrongdoer. The category of special relationship includes fiduciary nature, which involves relationship between parent and child, solicitor and client, doctor and patient, but not husband and wife. The reason for this fiduciary nature is because so that one can unduly control the mind of the other, their agreement shall be presumed to be vitiated by undue influence once the allegation is made. This leads to a presumption of influence in law. The presumption of undue influence arises if there is something suspicious about the transaction which calls for an explanation. The burden then falls on the other party to show that in fact there was no undue influence exercised. For example, it may be possible to achieve this by showing that the transaction was entered freely following independent advice. The case under presumed undue influence Class 2A involves the case of Curtis versus Curtis. In this case, there was a claim of undue influence in relation to a lifetime transfer which involved the presumption of undue influence. The presumption was engaged because the relationship was one of trust and confidence, and the transaction was manifestly to Mr. Curtis' disadvantage. Consequently, on the trust's appeal, the appeal was dismissed. Under Class 2B, claimant is able to establish the existence of a relationship of trust and confidence on the facts. This includes the relationship of husband and wife. This raises a presumption that influence has been exercised, and that presumption will be undue where there is something in the nature which calls for an explanation. An example is that a small gift between relatives might be easily explicable. A large gift may call for an explanation. The burden then falls on the other party to show that there was no undue influence exercised. Case under Class 2B is Goodchild versus Bradbury. In this case, it was held that both transfers would be set aside for undue influence. The presumption of influence was shown to exist between the great-uncle and the great-nephew, and the sale was not in the interest of the great-uncle. The great-nephew was unable to show that the great-uncle had acted freely in the transaction or with independent advice.
In accordance to actual undue influence in third parties, the elements which will render a contract voidable include: number 1, the third party was acting as the other party's agent. Number 2, the other party had either knowledge or notice of the undue influence exerted by the third party. In the case of CIBC Mortgages PLC against Pitt 1994, Mrs. Pitt was pressured by her husband into signing a mortgage in which he told her it was for a loan for the purchase of a holiday home. However, it was used to fund his stocks and shares via trade-in. Initially, her husband became a millionaire on paper, though he never cashed in his shares. Instead, he bought more. In 1987, with the stock markets crashing, her husband had lost everything and the bank sought to repossess the house. Is the contract voidable between Mrs. Smith and CIBC Mortgages? Let's break it down into 3 steps. Step 1. Is there undue influence? Yes, there was actual undue influence. Step 2. Is there a third party involved? Yes, the third party would be her husband in this case. Step 3. Which of the elements are fulfilled to render a contract voidable if a third party exerts undue influence? Was the husband an agent for the bank? No, he wasn't. Did the bank have any knowledge of the notice or undue influence exerted by the husband? No, they didn't. The elements for which a third party exerts undue influence were not fulfilled, and therefore the contract was not voidable. Considering presumed undue influence and third parties, the elements are the same of as actual undue influence, with the addition of constructive notice of the undue influence exerted by the third party. However, instead of a contract being voidable, here the charge is voidable, or the contract may be avoided. Constructive notice has two stages. Additionally, creditors may take responsible steps to rebut the presumption of undue influence exerted by a third party. These include, number 1, providing independent legal advice. Number 2, warning the surety of potential liability and risk involved. These two stages, starting with stage 1, is where an intended charge or guarantee is not on its face advantageous to the co-owner, and there is a substantial risk that the transaction had been procured by some form of legal or equitable wrong, including misrepresentation or undue influence. Then the lender is said to be put on inquiry. Regarding stage 2, where the creditor is put on notice of the risk of misrepresentation or undue influence by the principal debtor, if the creditor took responsible steps to ensure the surety entered the obligation freely and with the knowledge of potential risks and liabilities involved, then there may be no constructive notice and the charge may be not voidable. However, if the creditor did not, then there would be constructive notice, in which will consequently render the charge voidable. In the case of Barclays Bank plc against O'Brien, 1994, this is a case of misrepresentation made by Mr. O'Brien acting as a third party. His wife charged her property to the bank based on the misrepresentation he made as to the charge being limited to £60,000 and to last only a few weeks. In fact, the charge was not limited in the amount or time. Could the charge be set aside? Could the contract be avoided? In this case, there was misrepresentation made by an independent debtor, which was Mr. O'Brien. The creditor, however, did not take the responsible steps to ensure that the charge had been obtained without influence, or that Mrs. O'Brien was aware of the full extent of liability. It was held that Mrs. O'Brien's transaction was to be set aside. The same concept would apply for undue influence.
So, undue influence is discussed under Section 16 of the Contracts Act 1950. Section 16 defines the elements of undue influence as the first one: the wrongdoer was in the dominant position in his relationship with the complainant, and the wrongdoer used that dominant position to obtain the transaction. And thirdly, the transaction was unfair to a complainant. Section 16, subsection 1, there must be a special relationship between the parties that one party is able to dominate the other for his own advantage. In the case of Song Gek Bao against Chong Yong Wang and others, the judge allowed the plaintiff's case as to rely on undue influence. The party must show that the other party had the capacity to influence him. The influence was exercised, its exercise was undue, and its exercise brought about the transaction. None of these conditions were satisfied by the defense. Okay, so Section 16, subsection 2 discusses that the condition that a person possesses to dominate the will of another. In the case of Salwa Hanif against Haji Abdullah, the brother-in-law of the plaintiff took advantage of her when her husband was dangerously ill and unable to manage his business. The court held that in this time the defendants were greatly influenceable to the plaintiff, and the defendants could not prove that the plaintiff acted on her own will and not under undue influence. Section 16, subsection 3 talks about the burden of proof lies within the victim to prove that the other party was in a position to dominate his will and uses that position to obtain an unfair advantage over him, and that the transaction was unconscionable. In the case of Raghunath Prasad against Saiju Prasad, the defendant took a loan from the plaintiff upon the security of a mortgage. The defendant contended that the loan was entered into under undue influence. The Privy Council held that the relation between the two was not sufficient to establish undue influence. Section 16, subsection 3 precisely fits the situation of the parties in the case. However, it has not been proved that the lender was in a position to dominate the will of the borrower because the latter failed to discharge the burden of proof to show that there was undue influence. And now we'll move on to the effect and relief for undue influence under Section 20 of the Contracts Act 1950. The agreement is voidable at the option of the party whose consent to the agreement has been caused by undue influence. But if party entitled to a void has received any benefit, the court may set it aside upon such terms and conditions as the court may deem just. This gives the court power to restore parties to their original positions.
Now we will compare and contrast the doctrine of undue influence in English and Malaysian law. I will be taking 4 points, while my colleague Joshika will be taking the other 4 points. According to the case of Tengku Abdullah ibn Sultan Abu Bakar versus Muhammad Latif bin Shah Muhammad, 1996, the judge said, although Section 16 is based on the Indian Contract Act and is in fact in pari materia, which is itself based on English law, and thus we should use them to interpret as such, Malaysia must still listen to the words of Parliament and statute, in particular Section 16 of the Contracts Act 1950, and to not solely base our decisions with reference to English cases, which in recent times have demonstrated that certain approaches to the doctrine of undue influence does not accord with our own standards of society. Section 16, subsection 1 of the Malaysian Contracts Act includes elements of the defendant having the position to dominate the will of the other, and he also subsequently uses this position to obtain an unfair advantage over the claimant. Now, the Contracts Act doesn't actually classify actual influence and presumed influence into separate classes, instead choosing to put them into one section. However, in English law, as in the case of Bank of Credit SA versus Abudi, they actually establish 2 classes, of which Class 1 is actual undue influence and Class 2 being presumed influence. Moreover, Section 16, subsection 1 of the Contracts Act insists that there needs to be relations subsisting between the 2 parties, which means that there needs to be a relationship and previous history of dealing. However, English law does not assert that there needs to be a history of influence for undue influence to occur. One of the similarities between English and Malaysian law regarding undue influence is present in Section 16, subsection 2 of the Contracts Act, where a person is deemed in position to dominate if A, he has real or apparent authority, which also includes a fiduciary relationship. In English law, this is also present, where there is real or apparent authority, be it a fiduciary relationship or there is certain authority, then there can arise undue influence. Another difference between English law and Malaysian law in the approach of the doctrine of undue influence as a vitiating factor is the establishment of manifest disadvantage. So in Malaysian law, manifest disadvantage was applied in polygram records versus the search. In this case, undue influence was already established, and after that, the issue of manifest disadvantage was established. However, in English law, since they classified undue influence into classes of 1, actual influence, and 2, presumed influence, manifest disadvantage is harder to establish. English law primarily focuses on preventing victimization and in providing relief for undue influence. So in actual undue influence, the claimant does not have to show that the contract was disadvantageous to them, while in presumed influence, they have to show that there actually is a manifest disadvantage. Rebuttals are also an important aspect to consider because they determine if undue influence indeed constitutes to a vitiating factor or not. In Malaysian law, the rebuttal of independent legal advice is available, but having done so does not guarantee rebuttal of undue influence, as evidenced in the case of Inche Noraya, 1929. Similarly, in English law, the rebuttal of the claimant having sought independent legal advice is also available, but it's also not a guarantee of rebuttal of undue influence. This is made in reference to Attridge's case, which was elaborated upon by my colleague, Risma, where Lord Nichols elaborated on a third party guaranteeing that the complainant has entered into a transaction with some knowledge of the legal implications.
So I will cover the other 4 points, that is mental capacity, special relationship, burden of proof and undue influence on third party. Coming to mental capacity, according to Malaysian law, the state of mind of the innocent party is taken into consideration as impairment of the innocent party's decision-making process will result in an extensive dependency or reliance on the defendant. However, in the case of Rosri bin Darus versus Mansour in 2001, Jeffrey Tan held that confidence may be presumed to exist depending on the relationship of the parties. There is no English cases under undue influence when dealing with mental capacity or other handicaps. To support this, the case of Glanville and another versus Glanville in 2002, the elements of mental capacity was insufficient under undue influence and the case was dismissed. Moreover, in special relationship, for example, husband and wife, there will be no undue influence and is similar to Malaysian law. In the case of Royal Bank versus Edric shows that exaggeration of hope and fears which cannot readily construe as misstatement of spousal relationship. However, the burden of proof according to section 16, section 3 subsection A, the victim also has the burden of proof, and it is similar for English law where the burden lies on the influencer to show that the contract was not made under undue influence, and the victim also need to show that there was influence. Lastly but not least, undue influence from the third parties. English law takes into account the various ways in which the third party can acquire knowledge of the undue influence, as detailed as my colleague. Under Malaysian law, the contract is void. However, in the case of Pan Malaysia Equities, Sandrian Berhad versus Angeline Tan Away applies the principle of knowledge by third parties. To conclude, the equitable doctrine of unconscionability, that is, undue influence, will render a contract voidable according to English law. Additionally, in accordance to Malaysian Contract Act 1950, Section 16, subsection 2, a person is deemed to be in a position to dominate the will of another where he holds a real authority over the other. Both Malaysian and English law protects the weaker party from abuse or exploitation by the stronger party. In our presentation with regard to English law, we covered the distinction between actual and presumed undue influence, as well as how a third party plays a role in both respectively. By use of cases, diagrams and flowchart, we illustrated how this may occur. Furthermore, we covered the approach of Malaysian law towards undue influence and how it may render contract voidable by looking into the Contract Act 1950 as well as Malaysian cases. We looked into on which party the burden of proof lies, as well as the effect of and relief for undue influence. Finally, we differentiated between the approach of undue influence in English law and Malaysian law, and how different elements have different consequences to render a contract voidable, or how charge may be avoided in both jurisdictions.
In our conclusion, we made passing reference to the equitable doctrine of unconscionability, but it in fact relates very much to the doctrine of undue influence in section 16, subsection 3a. Both of these doctrines arose out of the laws concerned to protect the weaker party from abuse or exploitation from the stronger party, and it was set out by Lord Denning in the case of Lloyds Bank versus Bundy. This equitable doctrine of unconscionability actually relates to the concept of inequality of bargaining power, because parties are involved in such transactions that are seldom on equal terms. Section 16, subsection 3a in particular of the Contracts Act relies on the burden of proof when a party is in a position to dominate, and it appears to have applied this doctrine in considering just what constitutes to a vitiating factor. However, Malaysian courts have actually rejected this on the basis of there being a lack of precedent. Lastly, I would like to say that the Malaysian courts should further adopt this approach of unconscionability to determine what constitutes a vitiating factor alongside the doctrine of undue influence, because both are actually founded on equity.